When someone becomes either too sick or too mentally compromised to act on their own behalf, and there is no durable power of attorney that has been granted previously, then the law has a mechanism to solve that problem. It's called the guardianship and the conservatorship. Now, those are two different things, but often the power is vested in one person. A guardianship is a court appointment to look after the best interests of the individual who is not able to look after their own. The guardianship essentially gives the guardian the power to make decisions over where a person stays, over how a person is cared for, whether they're placed into a nursing home or not, how they're taken care of in a nursing home. The guardian has the power to remove them from the nursing home or place them in a different nursing home. Guardianships are necessary because the person cannot take care of themselves. Now, normally in this situation where someone asks for a court to appoint them as a guardian, the first thing that happens is the court appoints what's called a guardian ad litem, which is somebody to look out for the incompetent person's interests. And so the guardian ad litem will go and interview the person who is the subject of the guardianship and determine for herself or himself whether or not that individual can act on their own and whether or not they know their own mind and are acting rationally. If they are, they may oppose the guardianship, and if they're not, they may support it. The guardianship is necessary, as I said, to make sure that the person is well taken care of, that they receive food, that they're hydrated, if they live by themselves, that their house is cleaned, that sort of thing. The thing that goes with that is sometimes called a conservatorship, and a conservatorship is aimed principally at safeguarding the incompetent person's assets, their bank accounts, their property, their cars, anything, any personal property or real property that they own is considered to be the subject of the conservatorship. The conservatorship is aimed at protecting those assets, and the conservator has to make an accounting to the court. First of all, he has to gather all of those assets. In other words, the property, the deeds to the property, the deeds, titles to any cars, anything that in terms of bank accounts, certificates of deposit, that sort of thing. All of those are aggregated and placed into what's considered to be an estate, very similar to the estate that's created when someone dies. That estate then becomes administered by the conservator with the oversight of the court. The court will make sure that accountings are done and that statements are filed and that everything that is done by both the guardian and the conservator is done for the incompetent's best interest. Sometimes, long-running family feuds have their last act at death's door for someone who has become incompetent. Perhaps Grandpa has 3 children and 18 grandchildren and owns a huge farm. And everybody wants a piece of that farm and a piece of the money that Grandpa has. Well, in that situation, when someone becomes incompetent, they can't make a will any longer. And if there is no will, then in most cases, in that situation, the state determines how those assets will be distributed. Unfortunately, many times people ride in at the 11th hour and try to make off with assets on their own. Well, if a conservator is in place, he knows what assets are there in the house, and he can take pains to make sure that they are not removed without authority, and that if they are removed, that appropriate legal action is taken. Also, you often find situations where one child wants the incompetent to come live with them, and another child says, no, they are much too likely to harm my grandparent or my parent. In many instances, when people can't agree toward a person's end of life. They apply to become guardians or conservators, and they do that with the sole aim of secreting money and property to themselves. They use the information in the estate for personal gain, which they cannot and should not do. In that situation, where one or more family members do not trust the individual that is applying to become the guardian, they can either apply to become the guardian themselves, or the court can appoint someone called the public administrator, which is basically a public employee whose job it is to look after a number of public wards. And that is another way that a guardianship and a conservatorship is used to protect the interests of people who can't protect their interests on their own. So that's guardianships and conservatorships. If you found this interesting or useful or helpful, I hope you would smash the like button. And if you would, I'd love it if you would click on the subscribe icon and press the notification bell so that you can be notified whenever I release a video. If you have any comments or questions, please feel free to leave them in the comments down below. I answer all of my comments and I read them all. And if you would, I would appreciate you leaving a comment because it definitely helps out with the YouTube algorithm. Thank you for watching and have a terrific day.